global banking system was troubled by several banking failures. We are looking the holistic picture. We are looking at the picture pan India. All the banks which have floated this would be at risk.
First of all, Mr. Solicitor, to represent to the public by the draft scheme that we are going to write down the bonds. What do you mean by before?
Before the reconstitution,
So it can be written down before the reconstitution.
Not on 13.
Not under the scheme. The scheme comes into effect on 13.
Either you rely on the scheme or you rely on the master circular.
I am relying on the scheme. Let me read it again,
Please don't shake your head behind. Please see what is the effective date.
Yes.
Kind, if you don't mind, sir. But
I didn't say a word.
no.
I didn't open my mouth.
Okay, better, but no.
But please don't keep doing this. I didn't open my
No,
mouth.
no.
I didn't say a word. You got into this habit. I'm sorry. I don't like it.
You may
didn't
not
open
like
my
me.
mouth.
You may not like many
I
things.
didn't open my mouth.
Bhai, I told Mr. Kaul, you are unnecessarily udta tir le liya inhone. Out of 24 ministers, it was a physical meeting. Out of 24 ministers, 20 were present, including the Honorable Prime Minister. It is signed by the Honorable Prime Minister. There were 3 resolutions, different resolutions, including this one.
So 2 are on other subjects.
Other subjects.
Right.
One concerning Ministry of Finance, another this, my lord, that is Department.
Just read out. What is the resolution?
Your Lordship, my lord, have a look. And the next page is the resolution, are the 3 resolutions. Banking issues are very delicate. I'll read. This is supplementary note to the note for the cabinet of even number and even date, read with the note for the cabinet of even number and dated 8/3/2020 for sanction to the Yes Bank Limited reconstruction scheme 2020, which provides for reconstruction of Yes Bank Limited. Earlier, Ministry of Law and Justice in the Department of Legal Affairs and in the Legislative Department was consulted. Department of Legal Affairs and had communicated its comments to the Legislative Department. Duly approved vetted version of the Legislative Department was awaited. Therefore, while submitting the note for the Cabinet to the Cabinet Secretariat, it was requested that the Ministry of Law and Justice may make its views known in the meeting of the Cabinet, as RBI had stated that it would prefer that the reconstruction scheme is notified on 13th March 2020. Subsequently, Legislative Department has vetted the Yes Bank Limited Reconstruction Scheme 2020 and the proposed scheme as vetted is at Annexure 1, page 229. Against this backdrop, approval of the Cabinet is now sought for sanction to the Yes Bank Limited Reconstruction Scheme 2020, Annexure 1, page 229, which will be published in the official gazette thereafter, subject to such changes of drafting of consequential nature, if any, as may be considered necessary in consultation with Legislative Department, Ministry of Law and Justice. This has the approval of the Finance Minister. So this is what, and the annexure is the scheme as published, my lord, now, as notified. Let it go by the RBI regulations and the bond conditions.
We are retaining it.
Yeah, of course.
What are the submissions?
My lord, submissions are, my lord, your lordships have heard, my lord, Mr. Diwan at length. But, my lord, the concern of the RBI and the central government, and particularly SPI, there may be some repetition, but I'll not be more than 10 minutes. Your lordships would recall, lord, this is a risk capital. What was the purpose behind Basel III recommendations was the global banking system was troubled by several banking failures. There were several, my lord, banks throughout the world where there used to be failure. Therefore, they came out with a policy whereby you can float certain bonds where the writing down can be one of the options, which the Basel III the recommendation says loss absorbency feature, that in case the bank goes below a particular threshold, the loss would be absorbed by these bondholders. The bond therefore necessarily have to be of a larger amount so that a common man doesn't bear the burden. The ultimate object is to ensure that the bank survives, the depositors are not put to any loss, and the members of the bank or the shareholders of the bank are not put to any loss. Therefore, each bond is for an amount of rupees 110 lakhs. There is an information memorandum. Before I invest 10 lakhs, the information memorandum also mentions that in case of the second series, that if it is in the second series, there will be write down. There is no other option. And what was the incentive was you will get 9% in the first and 9.5% in the second. No, that was higher rate of income interest than generally banks give. So you take your chance, you take maximum interest at the same time, you also run the maximum risk. The difficulty is this, and this is the view all central government, the RBI and the SBI wants to present before your lordships. This is not a case of only Yes Bank Limited. For us, we are looking the holistic picture. We are looking at the picture pan India and what can happen, the judgment were to go one way and what can happen, if it were to go to the other way. After this Basel III norms, which culminated into the RBI circular, various banks, with a view to ensure that risk is protected, have issued 1 lakh crore such bonds, pan India. Now, two things would happen. In the event of any bank, for whatever reason, going below the threshold level, which is again prescribed by the RBI, it would be necessary, to, even if there is a condition that write down is the only option, or like in the second series, it can be written down, it can be converted. It will have to be converted. As a result, many banks may face the question of survival. Our SBI, I'll read only one paragraph from SBI's affidavit. SBI has said that whenever such a situation arises, there are always stakeholder consultations. They are not official consultations. The RBI senior officials meet, they decide what to do, who to invite, who will infuse the fund, who will ensure that the bank is saved, how the bank will be saved, what are the considerations, etc. Ultimately, the SBI, if I may say so, was persuaded that you being the largest bank, you invest 7,000 plus crore, 7,800 crores, approximately 8,000 crores. But they understood the RBI circular that we are dealing with a bond series which can be written down. Otherwise, there would be no bank or nobody who would infuse its equity if its equity is going to be diluted. Now consider a situation where when 1 lakh crore such bonds are already sold under a valid RBI circular which is not under challenge, which says that shock absorbency is a very essential and fundamental feature of this bond, you are forewarned that you can lose the whole thing if a particular contingency arises. There would be twofold problems. A, the banks would have no loss absorbency feature, though though the RBI circular permits. And second, no bank or any other investor would come forward and try to salvage the situation by infusing equity. Because SBI has already infused approximately 8,000 crore. But if it is to be distributed the way my learned friends want, they have taken benefit of these bonds. This is a pure commercial transaction. There are no human angles involved, so to say. Pure commercial transactions where you are with an open eye entering into a transaction that I am helping the bank to shield it from loss absorbency, and as a result I am getting more interest. They earn the more interest. It was a commercial decision and a commercial risk which you have taken. So all the banks which have floated this would be at risk. Even the context, even the textual interpretation also do not permit, in my respectful submission, the reading that writing down is contractually, legally or otherwise bad. They have not been able to show, except something shown here or there. The one question which arose, which has arisen in the order of the learned of the High Court is this. High Court says, what is, now we are at what stage? The first scheme said complete writing down. Second draft scheme, I'm sorry. Second draft scheme says, no, we have received representations, conversion is an option. The central government says, neither of these two. Let it go by the RBI regulations and the bond conditions. Meaning thereby, it is for the bank which issued the bond to take a call what to do. If it is written down for 5,000 crore worth of the series, I don't think there was any option for the bank or for anybody else to do anything. But for the remaining 2,000 or 3,000 there was a decision. The question arose, my lord, which is answered against me by the High Court is that the date on which the administrator took the decision, my lord, my learned friend has, my lord, argued at length. I'm not, my lord, going to do that. I'm just giving one new dimension to it. When the decision was taken by the administrator of Yes Bank Limited that I will write down, he was not authorized to do so. My lord, that is, my lord, the finding your lordship would recall. My lord, to which, my lord, though there is already a provision, my lord, just for immediate reference, kindly take my yesterday's affidavit. My lord, I have not said anything which is beyond the pleadings, beyond the record, or what is not submitted earlier.
Yes.
Kindly, my lord, come to page 7, my lords. I am sorry, my lord, page 6, para 17, my lord. Page 6, my lord, so get, my lord. Para 17. I state and submit that as per clause 5 of the scheme of reconstruction, as finally approved by the Union Cabinet, that is central government, the office of the administrator was to continue till expiry of 7 calendar days from the date of cessation of memorandum, that is 25th of March 2020, for a period of 1 week. My lord, it was a Friday, therefore, my lord, I have added 3 days, and my lord, the period which ends the administrator's tenure is 25th of March. Though the scheme came into force on 13th March 2020, the process of reconstruction of the bank attained completion only upon reconstitution of the new board on 26th of March 2020, as the central government had taken a decision to permit 81 bonds to be dealt with on its own terms, which would mean the decision by the administrator took the decision on 14th March itself, as he continued in office up to 25th of March
What does the
2020.
master circular said
Yes.
about when the bonds can be written down?
Whenever the scheme
No.
comes into
No.
on reconstitution. On
Reconstitution.
yes,
When does the reconstitution happen?
Lord, the reconstitution, Lord, would happen on not before 25th.
26th March.
Yes, my lord.
They are interpreting on the date the scheme is promulgated. And the scheme says this is the reconstituted scheme.
Yes, my lord.
Then why should
Reconstituted bank, my lord. I'm sorry.
March 2020?
My
I
lord,
want an answer from you. Why are you reading it as
my lord,
26th March 2020?
kindly have a look at, my lord, the scheme itself, my lord.
Given the chart, for very
Is it there in the first volume, Mr. Diwan?
Yes, my lord.
no, that is, just give me the season. Agreement is that it 20 constructed bank, board of directors, board of, there are limitations on transfer of shares. So reconstitution, transfer of shares.
My lord, kindly see, my lord. Yes, my lord. The lordships have 929, volume 3, my lord, of convenience compilation.
Constructed bank is. On when final scheme was bank for not equity on 17th, moratorium order on the third working.
Yes, I just saw. My lord, your lordships may kindly come to 3, clause 3, subclause 3. My lord, your lordships have paid clause 3, subclause 3. The investor bank and other investors, your lordships. The investor bank is defined as SBI. The investor bank and other investors shall invest in the reconstructed bank, and the reconstructed bank shall allot equity shares of the reconstructed bank at a price rupees 10 only, with face value of rupees 2 only, so and so. So, my lord, after the reconstruction, my lord, the infusion, capital infusion would, my lord, come. Then your lordships may kindly come to clause 5. Constitution of Board of Directors. Your Lordship gets, my lord, page 933. The office of the administrator of the reconstructed bank, appointed by the Reserve Bank of India, shall stand vacated immediately after 7 calendar days from the date of cessation of moratorium under paragraph 11, and a new board of directors shall be reconstituted comprising of the following persons. My lord, I am skipping that. Then, my lord, rest is not relevant. But the director under the scheme continues with a moratorium, so that there is no change in the equity, no disturbance of the equity. Now, in this context, my lord, the Yes Bank, through my learned senior friend, my lord, has given, my lord, a chart. What was to happen, my lord, at what time? My lord, I'm sorry, my learned friend. Yes, my lord, there is my lord, this is your note. My lord, this chart was handed over, my lord, by Mr. Diwan. This kind of a chart, my lord, was handed over. How the scheme was to operate date-wise. My lord, the position is like this. My lord, only one line argument, my lord. I think, my lord, according to me, it should satisfy a lot. I think that. My lord, kindly give, my lord, when, my lord, I'm sorry, but before your lordship sees that, my lord, before your lordship sees that, my lord, when the administrator gets the right jurisdiction, whatever power, authority to write down, when the scheme comes into effect, so prior to 13th of March, Lord, the scheme did not come into effect. So the question of clause 6 kicking in, namely the bond conditions to take its own course, would not. The very same scheme says
12th of March, the bonds could have been written down
it cannot, because there
in terms of the bond. Why do you require a scheme to write down the bonds? On 12th of March, the bond was effective.
my lord, without infusion of the equity, we would not, my lord.
There is that condition in the Reserve Bank's master circular that only upon infusion of equity can this written down happen. Is that the requirement of the master
Lord,
circular?
Lord, there has to kindly see.
You say, first of all, Mr. Solicitor, you represent to the public by the draft scheme that we are going to write down the bonds. And you invite objections. They object,
RBI, yes,
whoever be it.
yes, my lord, I am representing.
You take into consideration the object, and then you say in one of your notes, 3.4.6.3, then it would not be appropriate.
My lord, that
It would not be appropriate. This is one of the terms of the draft note, which
Lord.
is being placed for consideration by the cabinet.
but the
It is said that let us leave it. Ultimately, when this
My lord,
comes out, scheme says, let us not tinker with this. Whatever is there.
my lord,
So what-
can I read, my lord, both the notice, both the paragraphs? My lord, first of all, please, my lord,
Please
make,
come to 1053.
my lord, please, my lord, allow me to say one thing.
Please,
This is internal note. People don't take decisions on this. 1,000, my lords.
So far as we recollect, Master Circular says.
Yes,
for
Lord, kindly let us have a read.
For reconstitution, the bonds have to be written down. Before reconstitution or reconstitution. Construction or reconstruction. That is the word used in the Master Circular.
My lord, it has to be
Right?
prior to.
So why was it not done on 12th of March?
My lord, couldn't be because, Lord, there was
Or
a.
before the draft scheme?
But I understand your lordship's question. That forget RBI interfered. Forget that RBI stepped in. Forget that there was any contemplation of the scheme.
Right.
You yourself could have written it down. Lord, suppose the administrator take a decision, administrator appointed by the RBI takes the decision that RBI is now coming out with a scheme. RBI is now persuading others to infuse the equity. My writing it down without the scheme, I'm Lord arguing arguendo. My writing down the bond without the scheme and therefore without infusion of funds by the SBI would take the bank further down. My lord, the purpose was to save the bank, not to take it further down. And my lord, the RBI appointed administrator obviously was aware that RBI has stepped in and they are trying to solve the problem. My lord, please see 1053. My lord, let me read this. This is internal noting. The public or the bondholders are not aware of this. My lord, please have a look. RBI has stated that it is thus very clear from the above that as per RBI guidelines on Basel III capital regulations, write-off or conversion of 81 capital has to happen before write-off of CET capital. RBI has further stated that it is seen that the term sheet of 81 bonds provide multiple options providing only write-down or conservation or write-down, which could lead to possible litigation. They are objecting that if we bifurcate two series, there is a likelihood of litigation, discrimination, etc. To prevent any present and future litigation, the bond trustees of 81 bonds has proposed conversion. By this, now the second part starts. By this bonds are getting converted at rupees 51, which is close to the share price as per SEBI regulations. Now, this is what the central government, through the ministry, considers. Formula for preferential allotment as per SEBI rules. Effectively, because of new investors, as the other investors participating in the scheme are being allotted equity shares at rupees 10 per share, allotting 1.955 per share per to 81 bond, to 81 bond holders will tantamount to 81 bond holders getting 20% value of their investment with possibilities of future upside. With regard to treatment of 81, now this is the decision. With regard to treatment of 81 bonds, the extent guidelines, rules, regulations of RBI and bond conditions apply. Therefore, it may not be appropriate to modify these through proposed reconstruction scheme. Accordingly, related provision in the draft scheme furnished by RBI may be dropped. Malod, this is pure and simple a policy decision, policy concerning financial implications. Now, please see, Malod, 2.1 at page.
Plus the page number in the.
This is the master circular, Malod. This is, I'm reading from the master circular. It starts from page 96, Malod. I'm reading 356. Malod, volume 1 of the convenience compilation, page 356. Malod, this is also, Malod, argued, but let me, Malod, refresh your lordship's memory. Malod, 2.15. This is a part of the master circular.
Yes.
If the relevant authorities decide to reconstitute a bank or amalgamate a bank with any other bank under section 45 of the BR Act, my lord, here it was the first option, such a bank will be deemed as non-viable or approaching non-viability, and both the pre-specified trigger and the trigger at the point of non-availability for conversion or write-down 81 instruments will be activated. So, my lord, this can happen only on 13th March when the scheme is notified. Accordingly, the 81 instruments will be fully converted or written down permanently before amalgamation or reconstruction in accordance with these rules.
So what do you mean by before?
Before the reconstitution, my lords.
Before so it can be written down before the reconstitution.
Okay, not on 13.
Not under the scheme comes into effect on 13.
Either you rely on the scheme or you rely on the master circular.
Lord, I am relying on the scheme. Lord, let me read it again, my lord.
Scheme says
It might
will
be
not tinker with any part of the bond contract agreement.
Yes, my lord.
Those remain,
Yes, my lord.
right? Bonds do confer an authority
Yes, my
to
lord.
write down the bond.
Yes, that authority comes into play.
This figure has to be pulled before reconstitution. This is the master.
No, my lord, kindly allow me to read it. My lord, this would be crucial.
How do you
Kindly allow me to read it, my lord, from the beginning.
accordingly?
No, my lord, please, my lord, don't read it from there. My lord, let me read it fully. If the relevant authorities decide to reconstitute a bank or amalgamate a bank, here, my lord, we are dealing with the first contingency. Any other bank under section 45, such a bank will be deemed as non-viable or approaching non-viability, and both the pre-specified trigger and the trigger at the point of non-availability of conversion, write down at 81 instruments will be activated. My lord, this is the first contingency. Accordingly, the 81 instruments will be fully converted or written down permanently before amalgamation or reconstruction in accordance with these rules. My lord, the reconstruction would take place finally when the new board of
That something has to be read into a circular that finally when the board of directors take over from the administrator.
It is reconstruction, my lord. Please
So
read.
you say reconstructed bank is defined
That's to describe.
on and from the
Lord, that-
effective date 13th
My
of.
lord, kindly see the my lord, scheme again.
There is no.
Please see what is the effective date.
Yes.
Kindly, if you don't mind, sir. But,
I didn't say a word.
uh,
I didn't open my mouth.
okay, better, but no.
But please don't keep doing this. I didn't open my
No,
mouth.
but-
Didn't say a word. You got into this habit. I'm sorry. I don't like it.
You may
Bhai,
not
open
like
my
my,
mouth.
you may not like many
I
things.
didn't open my mouth.
Bhai, I told Mr. Kaul, you are unnecessarily udta tir le liya inhone. She generally does, but from the court. My lord, now kindly have a look at, my lord, the scheme. Kindly have a look at the scheme and see para 5, clause 5.
Start with clause 2.
Yes, my lord, let us have.
What is the effective
Let-
date?
let-
13th March.
No,
There is no effective date.
No.
that definition was dropped.
Yes, my lord.
That's why we showed your lordships there are a series of dates. When the bank gets reconstituted, equity can't be transferred. It's at the end of all that the reconstruction is complete.
At clause 5 stage, when the new board of directors comes.
Otherwise, you can't transfer
Lord.
equity, you can't bring in, you've got
My lord, before that, let me show Mr. Diwan's chart. Well, let me show Mr. Diwan's chart. And, my lord, thereafter, I'll take your lordship to the scheme. My lord, this is, my lord, the misunderstanding.
File the written submissions. We will look at
Yeah, yes, my lord.
Exhaustively.
No, my lord, just now, my lord,
Make any further submissions. We are not calling upon you today. It's only for the limited purpose
I
of
understand.
giving some opportunity
I-
to Mr. Mehta, because he felt that when we closed the arguments, we had not heard him.
No, my lord, I am grateful. I am really grateful. My lord, kindly have a look at this later. My lord, this page which was given just now. My lord, this is what, my lord, the Yes Bank has presented, and rightly so. But this is how the scheme operates. And I'll, my lord, justify this by showing, my lord, the clauses of the scheme. Please, my lord, see serial number 1. Steps of reconstruction under the final scheme. Your lordship gets? The first is the final scheme was published by the central government, that is 13th March. Yes Bank was to allot equity shares within 2 working days following the commencement of final scheme, that is 17th March. Then, my lord, this is under clause 3.6. Kindly mark this, my lord. Moratorium order to cease on the 3rd working day from the date of commencement of the final scheme. My lord, that is clause 11 of the final scheme. Then the office of the administrator to stand vacated immediately after 7 calendar days from the date of cessation of moratorium, and the new board of directors to take charge, clause 5.1. Continuation of an alternative board of directors of Yes Bank on or after. My lord, we are not really concerned with that. Please now see the scheme.
The reconstruction. And all
These are all steps of reconstruction which ultimately my lord, is over at clause 5 state when a new board of director takes over. Now, my lord, please see page 929. Please see, my lord. Let us see, my lord, what are the recitals. Page 929, can your lordship, my lord, allow me to show?
Yes.
Sub unnumbered paragraph 2. These are the recitals or statement of objects and reasons, my lord, whatever we may call. And whereas the State Bank of India and certain other investors have expressed their willingness to make investment in the Yes Bank Limited and to participate in its reconstruction scheme. And whereas the central government has accorded its sanction to the said scheme for reconstruction. Now, therefore, in so and so. Now, please see, my lord, investor means the investor bank willing to invest in the bank. Then investor bank means State Bank of India constituted under the State Bank of India Act. The reconstructed bank means Yes Bank Limited, a banking company having its register. This is to identify which bank is under reconstruction. Then, my lord, 3. My lord, I have read 3. I will not trouble your lordships with that. But please again come to, my lord, page 933, clause 5. My lord, let me, my lord, place it. The office of the administrator, your lordship gets. Now, my lord, 13th is the date on which the administrator will get to operate the scheme by taking a decision whether to write off or convert. In first series, there is no conversion option, so he has to write off. In the second, he will choose either of these. The office of the administrator of the reconstructed bank appointed by the Reserve Bank of India shall stand vacated immediately after 7 calendar days from the date of cessation of moratorium under paragraph 11, and a new board of directors shall be reconstituted. Please, my lord, mark. This is the reconstitution which is contemplated, comprising of the following persons. 1.15 mein majab. So, my lord, the purpose is after the scheme comes into effect, that is 13th March, the administrator continues till clause 5 stage reaches, and he takes the decisions as per the scheme.
The date of initial appointment of the administrator?
Initial appointment of the administrator.
5th
5th of March, my lord. 5th or 6th of March. Now, my lord, kindly also see clause 7. How, my lord, the word reconstituted bank is used.
See under any restraint from writing down the bonds prior to 13?
There is no trigger.
There is
Trigger.
Lord 250. No. Yes. He was under a restraint for 2 reasons. For 2 reasons. Number 1, the trigger is when the bank is reconstituted.
Trigger is when the bank is deemed to be non-viable.
But that non-viability is triggered when the scheme comes into it.
Today, it is always necessary that only after a scheme comes.
But
That,
that is so, Lord, that is so, that is, Lord, Lord, there cannot be.
A bank may not be non-viable in that sense, but there is some reason we cannot visualize. We are not banking people. But
Well,
for
there-
reason
there-
or the other, it is required to write down the bonds. When the bank is not non-viable, but some reason occurs in terms of the circular, other countries.
I do not know, my lord, what can be the consequences.
Be done. We are putting you this
Lord,
question.
we are dealing with, my lord, a situation where the appointed administrator by the RBI, who is aware that RBI is in the process of reconstitution, my lord, whether he can write it down or not, and my answer would be no, not till.
He can do it after the scheme. He can't do it before the scheme.
My lord, because the scheme permits him to do that.
Scheme does not permit, sir. Draft scheme permitted. Not the final scheme says, whatever bond situation is there, you do it accordingly. Why do you say that the scheme
My lord,
permits?
let me take yeah, my lord, what is, my lord, falling from your lordship to its extreme. Let me take it.
You say
No, I'm saying for argument. I'm not saying.
open to the administrator prior to the scheme to write down the. Please don't shake your head behind.